All right, Part 242, Title 49, Chapter 2, Part 242. Subpart E, Denial, Revocation, Certification. 242.401. Denial certification. Railroad shall notify the candidate for the certification recertification information known to the railroad that forms the basis of the denial for the person's certification, provided that the region for the responsible opportunity to explain or brief the adverse information prior to deny the certification. Railroad shall provide with the conductor candidate with any information and written document records, including the written statements related to the failure meeting requirements of the part with the support of the pending of the final decision. The instruction does not require the former further opportunity to comment with the railroad's denial whether it's based on the sole of the factor addressed in statute 242, 111, 115, or 403 with the opportunity to comment the affordable of the statute 242, 109 has been provided, and if the railroad denies the certification for the recertification, shall notify the person adverse of the decision, explain with written of the basis of the denial decision. The basis for the railroad denial decision shall address any explanation, rebuttal information for the conductor candidate may have provided with the written pursuant with the paragraph A in the section of the document may explain with the basis of the denied shall be served on the person with the 10 days after the railroad decision shall give the date of the inspection. Railroad shall not note to deny the person certification failing to comply with the railroad operating rule of the practices of the consistent to the violation of statute 242, 403, E1 through 11 of this part with sufficient evidence if it exists for the established the intervening with the cause of the preventive of the material impaired with the conductor's ability to comply with the railroad's operating rule or practices. 242, 403 criteria for the revoking certification. Each railroad shall adopt and comply with a program which meets the requirements of this section when any of the person included but not limited to each of the railroad officer, supervisor, each of the employee violates any of the requirements of the program which comply with the requirements of this section. This person shall be considered to be has violated with the requirements of this section. It shall be unlawful to fail to comply with any of the railroad rules. The practices described in paragraph E of this section. A certified conductor who has demonstrated failure to comply with the railroad rules and practices described in paragraph E of this section shall have his certification revoked. A certified conductor who is monitoring piloting introduction of the conductor fails to take an appropriate action to prevent the violation of the paragraph E of the section shall have this certification revoked. The appropriate action does not meet the supervisor pilot instructor must also prevent the violation of occurring at all costs. The duty may be met by the warning conductor or engineer as appropriate as the potential as for foreseeable violation. A certified crew who is called with the rail to perform the duty of the train crew other than the conductor or locomotive engineer shall not have his or her certification revoked based on the actions taken or not taken while performing their duty. Limitation of consideration prior operation rules complying with the data to determine whether the person may remain certified as conductor. Railroads to consider as operating the rule compliance data of the line the only conduct is prescribed in paragraph E1 through E11 of the section if it occurred within the period of the 36 consecutive months prior to the termination. A review of the existing certification shall be initiated promptly upon the occurrence of the documentation of any of the conduct described in this section. A railroad shall only consider the violation if the operating rules or the practices that involve 1. The failure to appropriate action to prevent locomotive engineer for the trainer for the conductor is assigned for the failing of the control of the locomotive of the trailing in accordance with the signal indication excluding hand or radio signal indication of the switch that requires the complete stop before passing. And then when the conductor is located with the operating cab, otherwise has only acknowledged signal indication. Appropriate action does not meet the conductor must prevent the violation from occurring at all costs. That duty may be met by warning with the engineer of the potential foreseeable violation. 2. The failure of the take of the appropriate action to prevent locomotive engineer for the training with the trainer or the train the conductor as assigned to the failing of the here of the following the limitations concerning the train speed. 1. When the conductor is located with the operating cab at the speed at which the train was operating exceed with the maximum authorized limit of at least 10 miles per hour with the railroad restricted speed is in effect. The railroad shall consider only the violation of the conditional clause with the restricted speed rule. The clause that requires the stopping within one half of the locomotive engineer's range of vision, the operational equivalent, therefore, of which cause the reportable accidents abundant in paragraph 225 of this chapter. Except for accidents and incidents that are classified and covered data under the statute 225.5 of the chapter, the appropriate the core action does not mean that the conductor must prevent the violation from occurring at all costs. The duty may be met warning the engineer of potential foreseeable violation. When not in operating cab, the conductor is deemed to have the operating action when complying with all the applicable railroad operating rules and special instructions. Or 3. Failure to perform and have knowledge of the required brake test with the performance pursuant to the Class 1A, 1A, Class 2, Class 3 transfer train brake test in Part 232 of the chapter. Class 1, Class 1A, Class 2 running brake test provided in the provision Part 238 of the chapter. Failure to take an appropriate action to prevent the locomotive engineer with the train conductor assigned from the occupying main track of the segment of the main track without proper authority of the permission of the appropriate action does not mean that the conductor that must prevent the violation from occurring at all times. The duty must be met with a warning of the engineer of the potential foreseeable violation. Failure to comply with the prohibitions against the tampering with the locomotive mounted with the safety devices, knowingly failing to operate the action with the prevented locomotive engineer from the train conductor is assigned for the failing to comply with the prohibitions against tampering with the locomotive mounting to safety devices, knowingly failing to take appropriate action to prevent locomotive engineer of the train conductor is assigned to be the operating and pertaining to the operator with the train with the unauthorized disabled safety devices controlling locomotive C, pending Title 49 CFR Part 218, Subpart D of the Appendix C of the Part 218. Failure to comply with this provision of Statute 218.999 for the chapter shoving and pushing movement of the railroad shall only consider the violation of the 218.99 with the chapter will cover the reportable accidents and incidents under Part 225 of the chapter, except for those accidents and incidents that are classified and covered data under Statute 225.5 of this chapter. Failure to comply with the provision for the Statute 218.101 with the chapter leaving the rolling and on-track maintenance of the off-way the equipment is clear. Railroad shall only consider those violations of 218.101 for the chapter that cause reportable accidents and incidents under 225 of the chapter, except for the accidents and incidents that are classified and covered data under Statute 225.5 of this chapter. 8. Failure to comply with the provisions of the 218.103 for the chapter the hand operated switches, including crossover switches, railroad shall only consider those violations 218.103 of the chapter which cause the reportable accidents and incidents under Part 225 of this chapter, except for the accidents and incidents that are classified and covered with the data in Part of Statute 225.5 of this chapter. Failure to comply with the provisions of the 218.105 of the chapter additional operating of the requirements of the hand-operated main track switch of the railroad shall only consider with those violations of 218.105 of the chapter because of the reportable accidents and incidents under Part 225 of the chapter, except for the accidents and incidents that are classified and covered data under the Statute 225.5 of this chapter. Failure to comply with the provision for the 218.107 in the chapter of the additional operating with the requirements of the hand-operated crossover switch of the railroad should only consider these violations 218.107 of the chapter with the cause of reportable accident with the instance on Part 225 of the chapter, except for the accidents and instances that are classified over the covered data under 225. 5 of the chapter. Failure to comply with the provisions of 218.109 with the chapter hand operated fixed rail with the derail of the railroad shall only consider with those violations 218.109 with the chapter will cover the reportable accident for the instance of the Part 225 of the chapter, except for the accidents instances that are classified and covered data in Part 225.5 of this failure. 12. Failure to comply with the Statute 219.101 with this chapter, however, the social incident of the charge are considered for this violation only with the Part 242, 405, 8, and 3. F1. If any single incident of the person conducting contravened with more than one operating rule or practices, that event shall be treated as a single violation for the purpose of this section. A violation with one or more operating practices, rule and practice described in paragraph E1 through 11 of the section occurred during improperly conducted operational compliance tests, such as the subject of the provision of the chapter purposes to be conducted and determined in the period of eligibility described in 242.405. An operational test that is not conducted in compliance with the parts of the railroad operating rules or railroad program under the Statute 217.9 of the chapter will not be considered for the legitimate test for the operation of skills and knowledge and will be not considered for the certification, recertification, revocation purposes. A railroad shall not be permitted to deny or revoke employees' certification based upon additional conditions or operational restrictions imposed in pursuant to 242.107D. Alright, 242.405 periods of the eligibility period of the eligibility described in this paragraph. The one begin with the person not currently certified with the date of the railroad written determination that must the report recent incident that has occurred. Beginning with the person currently certified on the day of the railroad notification to the person that certification has been denied or certification has been revoked. 3. Be determined according to the following standards. On other than main track where restricted speed for the operational equivalent there is an effect of the period of the revocation of the violation of Statute 242.403 E6 through 8 and 10 and 11 shall be reduced to one half of the that another revocable event has been occurred within the previous 12 months. In the case of the signal incident involving the violation one or more of the operating rule of the practice described in Statute 242.403 E1 through 11 of the person shall have his or her certificate revoked for the period of 30 calendar days. In the case of the two separate incidents involving the violation one or more of the operating rules or practice described in Statute 242.403 E1 through E11, they occurred within the 24 months for each other of the person shall have his or her certification revoked for a period of 6 months. In the case of 3 separate incidents involving the violation of one or more operating practices described in 242.403 E1 through E12 has occurred within 12 months of each other, the person shall have his or her certificate revoked for a period of 1 year. In this case, if the four separate incidents involving the violations of one or more of the operating rule for the practice described in 242, 403, E1 through 12 that occurred within 36 months of each other, the person shall have his her certificate revoked for a period of 3 years. 7. When in the purpose of the occurrence of the violation described in 242, 403, each 12, the different period of the ineligibility may result under the provisions of the section 242, 11.5. The longest period of revocation shall control. Any all periods of revocation provided in paragraph A of the section shall make the consist of the training. Reduction of the period of the ineligible person with a certification with the denied of revoked shall be eligible for the grant. Reinstatement of the certificate prior to the expiration of the initial period of the being of ineligibility only if the denial of revocation of the certification in accordance with the provision of the paragraph A3 of the section of the period of 1 year or less. The certification is denied revoked for the person for the reason of non-compliance with statute 219-101 of this chapter. The person evaluated the railroad officer determined to have received adequate remedial training. The person successfully completed the mandatory program of the training, retraining if it is determined to be necessary for the railroad prior to the return to service. At least one half of the period with the ineligibility specified in paragraph 813 of this section has elapsed. Alright, 242.407 process revocation certification. Except for the provided in paragraph 242.111.5G, the railroad certified the recertified person for the conduct for the during the period of the certification is valid requires reliable information regarding violations of statute 242.403E with the 242.11.5E with the chapter will still revoke the person's conductor certification pending the revocation of the determination of the section of the railroad shall, upon receipt, reliable information regarding the violation of the statute 242.403E or 242.11.5E with the chapter immediately suspend with the person's certification prior to the upon suspending person's certificate, provide notice for the region with the suspension of the preventing the revocation of the opportunity of the hearing before the presiding officer or other investigating officer. The notice may initially be given other orally or written, but given the orally must be confirmed with the writing. The written confirmation must be made with the promptly written confirmation with conforms. The notification provision of the applicable collective bargaining agreement shall be deemed to satisfy the written confirmation requirements for this section. In the absence of an applicable collective bargaining agreement provision, the written confirmation must be made within 96 hours. Conveying the hearing within the 98 deadline prescribed in the paragraph. Each paragraph of the C1 of the section of the applicable collective bargaining agreement is permitted under paragraph D of this section. 4. No later than conveying of the hearing of the notwithstanding of the terms of the applicable collective bargaining agreement, the railroad conveying of the hearing shall provide with the person with a copy of the written information with the list of the witnesses of the railroad will be present for the hearing. If the request recess at the start of the hearing will be granted, the information is not provided until just prior to the conveying of the hearing. If the information was provided through the statements of the employee of the beginning railroad, the railroad will make the employee available for the examination during the hearing required by paragraph B3 of the section. Examination may be telephonic where it may be impracticable to provide a witness at the hearing. 5. Determine on the record of the hearing whether the person no longer meets the certification requirements of the part still stating explicitly the basis of the conclusion reached. When appropriate info of the pertinent period of the revocation provided in the statute 242.405 and 242.11.5, retain the record of the hearing of the 3 years after the day of the decision rendering except the provided in paragraphs D, F, and I, and J of this section. A hearing required by this section shall be conducted in accordance with the following procedures. 1. The hearing shall be conveyed within 10 days of the day of the certification suspended unless the conductor requires the consent of the delay of the start of the hearing. The hearing shall be conducted by the presiding officer, which can only any proficient with a person authorized by a railroad other than those investigating officers. The presiding officer will exercise the power necessary to regulate with the conduct of the hearing for the purpose of achieving the prompt fair determination of all the materials issued. The controversy. The presiding officer shall convey, presiding over the hearing, the testimony of the witness at the hearing of the record verbatim. All relevant probative evidence shall be received unless the presiding officer determines that the evidence is due to unduly repetitive or so extensive that lacking in the relevancy that his admissions would be impaired the prompt and orderly fair resolution of the proceeding. The proceeding officer may adopt the need for the procedure for the submission of evidence in written form, examine the witness at the hearing, convey the recess of the adjourn, and otherwise regulate with the course of the hearing, take any other action authorized by consistent with the provision of the part permitted by law, that may expedite with the hearing and aid with the disposition of the proceeding. 8. Parties may be heard on their behalf throughout the designated representative of the parties may be the author of relevant evidence, including testimony that may conduct such examination of the witness as may be required for the full closure of the disclosure of the relevant facts. Alright, and the record and proceeding shall be closed at the conclusion of the hearing unless the presiding officer allows the additional time of the submission of information. Each such instance Record shall be left open in the shell time of the presiding officer grant for the purpose of no later than 10 days after the closure of the record. The railroad officer official other than the investigating officer shall prepare and sign the written document decision for the proceeding. With the decision shall contain the finding for the fact of the well of the base for thereof the concerning all material issue for the fact of the presenting for the record of the citation to applicable railroad rules and practices to state whether the railroad official found the revocable event with occurred with the applicable period of revocation within the citation of the Title 49 CFR 242-405 periods of revocation, and 3. Served on the employee and the employer's representative if any of the railroad retain proof of the service. 12. The railroad shall have the burden with approving with the conductor's conduct which is compliant with the applicable railroad operating with the rule of the paragraph of the 219 with the chapter of hearing required with the section with which it is conducted for the manner that conforms procedurally to the application of collective bargaining agreement that shall be deemed to satisfy the procedural requirements for this section. Hearing required under this section may be consulted with any of the disciplinary other hearing arising for the same fact for the all instance the railroad official of the other than the investigating officer shall make the separate findings as the revocation required under this section. If any person may waive the right to the hearing provided under this section, the waiver shall be made in writing to reflect the fact that the person has knowledge and understanding of these rights and voluntarily surrenders them. B3. Be signed by the person making the waiver. The railroad shall be relied on the certification of the railroad under the provision of 242-127, 242-301 shall revoke its certification if during the period of certification is valid with the railroad acquires information with the conveyance in another railroad is revoked the certification in accordance with the provision of the section. The requirements of the provide with the hearing under this section is satisfied. When any of the single railroad holds the hearing, no additional hearing is required provided the revocation by many with more than one railroad arising from the same facts. Alright, 8. The period of certificate suspended prior to the commencement of the hearing required under the section shall be credited towards the satisfying applicable revocation period of the imposed in accordance with the provision of the statute 242-405. The railroad 1 shall not revoke the person's certification provided within the further paragraph A of the section. Sufficient evidence exists to establish that the intervening of the cause of the prevent the material impaired with the conductor's ability to comply with the railroad's operating rule for the practice which constitute the violation of statute 242-403 E1 through E11. May decide not to revoke the person's certification as provided within paragraph A of this section with sufficient evidence for the exists to establish the violation 242-403 E1 through E11 was minimal in nature and had no direct potential effect on the rail safety. J. The railroad shall pay for the relevant information from the record maintenance and comply with the statute 242-215 with the Class 1, including National Railroad Passenger Corporation Class 2 railroads, and 242-303 for the Class 3 railroads. Sufficient evidence meeting the criteria provided with paragraph 1 of the section will become available either 1 prior to the railroad action suspended. The certificate is provided for paragraph B 1 of the section prior to the conveying of the hearing provided with this section. Provided that the railroad makes a good faith determination after the reasonable inquiry with the courts for the conduct provided in paragraph I of this section appropriate with the railroad which does not suspend a conductor's certification as provided in further paragraph B of the section is not violation of paragraph A of this section. Subpart F. Dispute Resolution Procedure.